a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting, well-known Melbourne solicitor, is about to take your calls and offer you some free advice. You don't have to take it if you don't want to, but he's got it. David Whiting, good morning.
Good morning, Virginia.
No
Lots
obligation.
of people don't take my advice.
It's a no-obligation free quote.
Indeed, without the quote bit.
Without
Yes.
the quote bit, that's right. How are you?
I'm very well, thank you.
What's
Enjoying
happening in
the
your
cold.
world?
The only thing exciting I did on the weekend was I walked from Brunswick to Richmond. I thought it was a fair hike.
That's a fair
to
hike.
Do.
How long did that take?
2 and a bit hours.
Nicely done.
Yes. So we're having quiet times at the moment.
We are
Haven't been to a
indeed.
football match in, gee whiz, 4 or 5 months.
And you're the problem then. With declining numbers at the football matches. It's a David Whiting-led issue here.
Yes, okay.
Did we have homework from last week?
We had one caller last week whose there was a power cable from SP Ausnet that supplied his home.
Yes.
And a council tree fell over and pulled the cable down. He received an account from the electricity company and wanted to know why they weren't sending it to the council. Again, it's this amazing piece of legislation called the Road Management Act, which provides an exculpation or excuse for council for what we call non-feasance, which is failure to look after something.
As opposed to malfeasance, non-feasance.
Yes.
I love it.
So
I wonder if you can just use feasance.
And it arises, the large parts of the Act arise from things like tree roots from council trees that somebody falls over, and they thought that would be just imposing too high an obligation on council. We want the trees, but the roots are a consequence. So answer would be, I don't see that the council has a liability unless you're able to establish that they didn't manage the tree properly.
Well, if the tree fell down and it's a council tree, how can it not be the council's responsibility?
Because there needs to be, we get to this non-feasance thing.
Yeah.
If the council pruned the tree and didn't do it properly, or if the council inspected the tree and decided work needed to be done and didn't do it, then there's a failure to do. But failing to look at the tree, which ultimately then fell over, is non-feasance and no thank you.
Joe, they've got an out for everything, haven't they?
Well, yes, because imagine what...
What do you say? It's never anybody's fault.
Yeah, never anybody's fault. Yep.
That's right.
Well, it's never my fault. Or alternatively, it's always someone else's fault.
Exactly.
Yes.
So the upshot for our caller?
Is, I'm really very sorry, the bill's yours.
Oh, dear. Wow, it's a
At least the
big bill.
tree's not in the way anymore.
Well, yeah, big bill though. 1300 222 774 if you would like to get some advice. Glenn in Langwarrin, go ahead.
Hello.
You're on the air, Glenn. Go
Oh,
ahead.
sorry, I didn't expect to be up first. Yeah, look, a question. I had a brand new unit was rented out. Tenants moved in. They were the first tenants, obviously. They left the property. The estate agent said there was no damage, gave them the bond back. The next tenants who moved in, they took photos of damage that was actually done there, the first tenants, which the landlord said, yeah, they missed.
So what's happened is the agent has done a final inspection, decided nothing to see here, it's all right to release the deposit to the old tenant.
Yep.
The security deposit's gone. Yes, you do have an action against the agent for the loss that you've suffered as a consequence of the agent's failure to pick up the problems.
Good. Because they've offered to go on to pay VCAT on my behalf, but I don't want to have to go to VCAT when they haven't done their job properly. I'm assuming that's on them rather than...
Well, the primary obligation rests on the old tenants. So I think what they're doing is the right thing, is there's an action against the old tenant. But what you need from them is their agreement to pick up the tab in the event that they lose against the tenant.
Okay.
And also pick up against the agent in the event that they can't get money from the old tenant because there was a cash deposit, the cash deposit's gone. What's to say that the old tenant has the money?
Yep.
Good luck.
Thank you. Thank you very much.
Hope that's helpful. It sounds hard. Isn't there some sort of recourse against the agent because they didn't do the inspection properly?
Yes, there is, but the primary obligation... So you might have a go at the tenant, you might have a go at the agent for failing to, and then let the agent join the old tenant for the cost of fixing.
Right.
Yes.
Okay. Ramona in West Melbourne. Ramona, how can we help?
Oh, hi, Virginia and David. I'm just calling. I have had a friend passed away. There was no will. Now, he owned a property, but he still has a mortgage on it and like a few vintage cars. He was currently separated from his wife, so it was all these things are in his name, but they are still legally married.
Yep.
His mother would like to move into the house.
Ramona,
Yes?
the absence of a will and the separation, but not a divorce, means that it is almost inevitable that the separated partner is the person who will inherit. Now,
Okay,
that
so
may
she'll
not
be
be his
the next of
intention.
kin.
Beg your pardon?
Yeah, so would be the next of kin. It'll be up to her, will it, to apply for probate?
No, not the
She
mother, the
applies
partner.
for the partner. She applies for the letters of administration.
Hang on, let's just get this clear. You're talking about the partner, but you're talking about the mother. Is that right, Ramona?
Yes, and they're very close.
The mother
so I'm
has
just
no. The
wondering-
mother has no standing, Ramona.
Okay,
So
mother has no
if you
standing.
separate, I mean, if you go to a family lawyer and say I'm now separated, the first thing they get you to do is make a new will.
Because it'll all go to them otherwise.
Because otherwise your wills, and the divorce brings a will to an end
Yes.
as a general principle. But if you don't have a will, then but in this particular case, they're not divorced. In the absence of the divorce, it's the estranged partner who inherits.
Okay, and so what is the first step she has to do to get things changed? Like, do we just contact
She is
state
going
trustees?
to need letters of administration, and she would normally go off. There are forms you can download from the Supreme Court website if you want to. There are kits that you can get, legalkits.com.au can sell you a legal kit if you want to do it yourself, or you go and see a lawyer.
Okay.
Good luck.
But
Thank you.
I have one for you, and that I don't have the answer to, Virginia. I'm a VCAT appointed administrator for a person who I know doesn't have a will. Mm-hmm. What happens when he dies? So think of now state trustees will be the people who will administer the estate. What happens between, he dies on a Friday afternoon. I can't ring an undertaker. My role as an administrator is now gone. What happens?
Is there no one else? No, next to kin?
No, there is no one. There is no one else. So I suppose I need to talk to state trustees and say, what's the strategy, people?
Yeah.
Or do I organise his funeral now, because I can prepay his funeral, and then have the discussion with state trustees when he's
Can't a will be sorted?
the reason why I'm an administrator, he has lack of capacity.
Right. Okay.
Can't make a will.
Right.
Has no. Under the rules of inheritance as they operate in Victoria at the moment, the state government's going to get everything. What happens to him in the meantime?
Yeah. No, I don't have the answer for you.
No,
but
okay.
I didn't think you expected one from me.
No.
It was a
I'm just
rhetorical
putting it
question.
out there.
Yes,
Just putting
indeed.
it out there. Yep.
Okay. Emily in Burwood. Emily, go ahead.
Thank you, for David and Virginia, for taking my call. My question to David is, my brother's building a domestic home. The builder is continuously lying, and there's been a delay, quite a long delay. So my question is, David, if my brother was to offer the builder, say $25,000 or $50,000 because it's only the inside that needs to be completed and the driveway. If he was to ask and offer this amount of money to get it completely finished, can my brother put an existing clause into the existing building contract and say that it must be finished at least between 4 to 6 to 8 months?
Emily, I had a similar position, not quite the same, where a client came to me who had a building contract in Queensland of an investment property, and the builder wrote to him and said, can we have an extra $40,000 please, otherwise we're going to go broke.
Yeah.
So the suggestion that I put to the client was that you give him a completion bonus.
Okay.
So you make an offer to, and my view in relation, while he had the right to terminate the contract, if he was to terminate the contract, as it seems like your brother probably, if he goes through a few steps, might have the right to terminate the contract, is that doesn't, so the process is you require the builder to resume diligently, and maybe the builder comes back, but let's assume that the builder doesn't come back, you terminate the contract. The builder's entitled to something for the work that's already done, and you're never going to be able to find a builder in this market who will be able to complete the contract for the balance of the price.
Right.
So
No,
your
I
brother
understand.
will be out of pocket whichever way you look at it.
Yeah.
So I would be suggesting that you go to the builder and you offer him to vary the contract by including a completion bonus.
Okay.
That if the builder
And
gets it to this point by this date, you will give him an extra amount of money that you might negotiate.
Oh, okay.
So
And
you're...
also,
Yes?
Also, I know the builder doesn't have his building sign, which includes all the emergency details on it. Can you tell me, is that illegal or is it legal?
He's got an obligation under the Building Act to put the sign up, but that's not your brother's offence, that's the builder's offence.
So if you actually insist that you want it up, I guess you talk to him about it, but it sounds like you've got a tricky builder to deal with there. Daryl in Fairfield. Daryl, what's your question? Good morning.
Hi, Daryl.
You can be Daryl.
That's all right.
You can be Daryl.
Hi, David. Hey, we have a small piece of body corporate land, and the other day, contractors turned up and installed an electrical switchboard on this land. Anyway, we found out it was being installed by the neighbour, who's not part of the body corporate, and so I spoke to the electricity company, and they said it wasn't their asset and they didn't install it. And we spoke to the Ombudsman, and the Ombudsman said, well, we can't do anything because it's not the electricity company who's done this.
Yes.
So I'm just wondering, how do we get this thing removed?
It's an action by, well, depends how bloody minded you wanted to be. The Owners Corporation would have the ability to have it removed because it's something that's been added to Owners Corporation property, but you're then going to interrupt the supply of power to the neighbour. So why don't you talk to the neighbour about getting it removed? Otherwise, it's the Owners Corporation that has the power to do something.
Yeah. And were any permits required to install such an item?
Unlikely.
Really?
Well, so if you... I mean, logically, the property belongs to the Owners Corporation.
Yeah.
I presume that the switchboard, apart from its location, complies with every requirement under legislation. You don't need
Why
a
do you
permit to
assume
put in
that?
a switchboard. You don't need a permit to put in a switchboard.
Yeah, but I wouldn't assume that it complies. I mean, it wasn't put in by the power company, so you can't
no,
assume
but the
that.
power company, your electrician puts in the switchboard.
Yeah.
The power company then connects to the switchboard.
Is it connected, Daryl?
Yeah, it's connected, but it's got nothing to do with our body corporate. You know what I mean?
No,
It's
I understand.
Connected to the, it's connected to the
But how did
neighbour's
it get
property.
connected to the power if the power company wasn't involved, Daryl?
No, the electrician asks the power company to say it's installed, it's functional, so the electricity company then connects power to the switchboard, which then gets distributed through the area serviced by the switchboard. The problem is that the switchboard's been installed on a neighbour's property.
I get that, but who's paying for the power, Daryl?
Well, it's the neighbour's power.
Okay.
Yeah. Yeah. And so, what action do we take? Like, is this magistrate's court?
I think you've got the self-help option, where the Owners Corporation
Just
could
removes
remove it. And you've got the option where you negotiate for the neighbour to remove it, and you've also got the option where the neighbour rents the space in the body corporate for it, and your final choice would be to go to court to force its removal.
Can I just ask a question? I know it'll be occurring to listeners. Do you have a sense why these neighbours couldn't have put it on their own property?
Well, they told us that that's where the power company said it had to go. You know, and that's the only explanation we've got so far.
But there is no power company that was involved, so you're saying that's an untruth?
Well, yeah, probably, yeah. The power company they just came and turned off the power while it was being installed, and then came back and turned the power back on when it was done.
They did? Okay, so I was trying to establish.
Yeah, but all they do is disconnect and connect on the basis of a certificate from an electrician. So, and there are regulations as to where switchboards go, but one of the requirements is that the switchboard be on your property, not on someone else's.
Well, could you do it that way? Could you just let the power company know from the body corporate, hey, this is on our land.
Yes, you could.
We didn't authorise it. Come and turn it off, please.
Yes, we don't want power connected to our property. Remove it.
That's right. Okay. Well, see which
That's
way you go.
option number 4.
As the challenge is, you can be as bloody minded as you like, or as you're prepared to be. Margaret in Bacchus Marsh, what's going on?
Yes, good morning. Thank you for taking my call. I have a unit and with a title, and it also has a separate title for the car park space at the back of the unit, a block of 4 units.
Yes.
I'm just wondering, David, if you've come across this before, and what my problem is Centrelink have valued my property, and they've valued the unit at the car park space at the same price as my unit, and they've taken me over the assets test.
Margaret, my guess is a third of the units in Victoria with car parks have a separate title for the car park.
Okay, so it's not unusual.
I don't know you. They now draw plans of subdivision differently, so that you would have unit number 3, for example, but it would be in 2 parts, the residential part and the car park. It's a mistake at Centrelink. It should be relatively easy to fix. If you have a copy of your plan of subdivision and copies of your titles, take it to a Centrelink office.
Oh, I've been, believe me, I've had 2 interviews. It's now with some independent review.
Yes.
And they are refusing to hurry it up. They said it would be 59 days.
Yes.
Why 59, I don't know. 59 days before there would be a decision. In the meantime, they've cut my pension in half.
I would also suggest you have a discussion with your local member. That is your federal member of parliament. They agitate better than I do, Margaret, or you.
Okay, Margaret, we wish you all the best with that. Thanks so much. Jen in Blackburn. Jen, what's going on?
Oh, hello. Hi. Thanks for taking my call. This is for my friend. So my friend has a restaurant in the city that opens in the evening and night. About 2 weeks ago, they had to close the restaurant for a day because of the COVID case of an employee. They had a sign on the door saying the restaurant is closed for the day. Unfortunately, that happens to be the day when the company who was going to do some gas pipe replacement or something similar came to a restaurant and other shops in the same area to notify them of the upcoming work. My friend and husband weren't there because the shop was closed, so they didn't get the notification. Anyway, late Monday night last week, they found out the gas wasn't working. They freaked out and started to ring places. The company said that they thought the restaurant was going to be closed for a week, not a day. So without turning the central switch on, they couldn't use the gas, but the only access to that was through another restaurant underneath theirs. However, the owners of that shop went on holiday for a week, so the shop was closed and there was no way to get in. Anyway, so until Tuesday afternoon, my friend and husband were given the impression that the gas was going to be back on time for the business to start that night.
Jen,
but it didn't.
Jen, you want to, and I take it you're not getting any feedback from the gas company? I would suggest that you talk to the Essential Services Ombudsman, and your first issue is to get the gas reconnected and then to have an argument about compensation.
Okay, sure. Okay, yeah, because I thought, you'll get at least written notification, 1 or 2 weeks beforehand.
One would, but the process is still the same. Talk to the Essential Services Ombudsman and get a better reason for why it was cut off, get it reconnected as a matter of urgency, and then have an argument about the money.
If Jen speaks to the Ombudsman, can the gas, is that a long process? Can the gas be quickly restored?
Well, unless there's some works that are preventing it, I would have thought it would be almost immediate.
Really? They can work that quickly?
Yes.
They can? Okay, good to know. Jen, we hope that's helpful. There you go, the Essential Services Commissioner. Mark in Rosanna. Mark, go ahead.
Oh, good morning, Virginia and David. Thanks for taking my call. It's another will question. My son passed away a couple of years ago without a will. That's my understanding of it. And he was a lawyer to make things a bit more complicated. And part of his work, he would actually get paid in shares with the companies that he worked with.
Yes.
Some of the shares were in private companies, some were in publicly listed companies, but he would always put the shares in another company of which I'm often named as a co-director.
Yes.
With him being the other co-director.
So he would have a company that held the shares for him called XYZ Proprietary Limited. Yep.
Correct.
And it was the shareholder in a number of companies. So where's the question?
Oh, well, I don't really understand how to transfer the ownership from his name or the company's name into my name.
So who were the shareholders in XYZ?
Myself.
Yes.
And him.
And
so often
him,
we were
right.
co-directors.
Now, are you, forget the director bit, are you entitled to the whole of his estate?
No.
Who inherit? Well, the shares that he owned in the company are part of his estate, and ownership in those shares passes to who his beneficiaries were.
Right. That would be my daughter-in-law, who we haven't had any contact with her since his passing.
That's a different question.
Right.
So he is still in his estate is entitled to the shares. It is possible for the shares to be transferred into, well, presumably your daughter-in-law's name, unless you're arguing that there was a different deal or arrangement in relation to the shares and can prove them. So I would have thought that his shares, part of his estate, passed to her. If she got a grant of probate, and even if she didn't, it would still be possible for XYZ Proprietary Limited to agree to transfer the shares to the beneficiary of his will.
Right. Would that require my signature or
You
approval?
are the sole director, so you're the person who registers the transfer, but there is no transfer yet to register. That's a process that you need to go through.
Okay, Mark?
Is there a specific type of lawyer that I should...
I would be going back to the lawyer who acted on your son's probate application.
Okay, so we'll leave it there, Mark. I hope that's helpful. I think we can fit one more in. Vanessa in Upway. Vanessa, what's the issue?
Oh, thank you, Virginia and David. I'm a patient advocate and I need to attend a meeting with hospital management. I just wanted to check, if I'm a party to the conversation, is it legal for me to make an audio recording of the meeting?
Are you going to tell the other people or aren't you?
I'm going to tell them, yes. I just want to know if they say no.
They are not required to... They can refuse to speak at a meeting that you're recording.
Okay.
All right, now you can ask that it be recorded. You might invite them to record it at the same time, but you can't compel them to attend a meeting that you're recording.
Is there a pressing need to record, Vanessa?
It's just we've had lots of misinformation and...
So Vanessa, my strategy would be this, if let's assume they disagree to the recording of the meeting, what you do is you send them an email as soon as you leave the meeting to cover what the agreed outcomes were for the meeting.
You take notes during the meeting?
Take notes.
They can't stop you doing that?
They can't stop you taking notes, and then at the end of the day, you, in the nicest possible way, you verbal them. You go back to them.
As agreed and as discussed. And of course you said and I said.
Here was my problem.
Yep.
The agreed outcome is, and the agreed time frame is, and at that stage you're at the point where you've got exactly what you want.
You verbal them.
Because they have to disagree with you.
Can you not put it in terms of you verbal them? That's a little fairer. We notate the meeting, right?
Yes.
We take notes.
Yes.
And then we share the minutes of the meeting.
Indeed we do. Yes.
Otherwise known as verballing.
Yes.
Thank you.
What I found, Vanessa, is the person with the best notes wins.
Yeah, There you go.
Perfect.
So be the best note taker. Thanks, Vanessa. Before you go, Peter in Richmond has texted in, do you roll your eyes every time a caller says thank you for taking my call? I don't do that, do I?
No, you don't. I mean,
No.
I just... people seem to think it's potluck, but it's not potluck. We generally take them as the order they come in.
People are being polite, and I completely understand that you are well raised and that your mother would say to you, say thank you for taking a call, but let me assure you, and no, I don't roll my eyes, let me assure you, you do not need to thank us for taking your call.
You do roll your eyes at some of the questions. That's different.
Would you stop telling tales out of school?
Goodbye.
Did I ask you that? Was that
No,
the,
you
no,
didn't.
that was not. Did you answer it anyway?
Yes.
Yes, you did. It is our job. We are paid to take your call, and we are pleased to take your call. So it is unnecessary, correct?
I do apologise.
Get out of here. And he can't even keep a secret. I didn't know that. So much for the discreet lawyer, eh? Never roll my eyes. I did get a very famous text message a little while ago which made me laugh and laugh, which said, Virginia, stop it. I can hear you rolling your eyes. I can't remember what the circumstance was that prompted that message, but the texter was dead on right. Absolutely correct. I didn't know that my eyes made a sound when they rolled.